Can you obtain a power of attorney if you have a dementia diagnosis? That's what we're going to be discussing today. So this is a very common cause of confusion because there's some people who erroneously believe that immediately after a dementia or Alzheimer's diagnosis, they are then unable to make decisions for themselves and therefore unable to sign a durable power of attorney, giving someone else the ability to do for them when they can't do for themselves. However, the reality is more nuanced than that. The reality is dementia or Alzheimer's is a spectrum. Right? It's not just either have capacity or don't have capacity. There are the earlier stages of dementia where people are very lucid, very clear, very much able to make intelligent decisions for themselves. And of course, on the very opposite end of the spectrum, there are folks who don't know what day it is, they don't know who they are, they don't know who their family are, and very sadly, obviously cannot make or not in a position to make any kind of decisions for themselves. So we have to really evaluate the client as they come to us. And as lawyers, we are able to make the decision as to whether or not our client has capacity or not. And we will do in our office, we conduct what we call a capacity check, where we ask the client certain questions to make sure that they understand what it is that they're doing. Now listen, our power of attorney might be 8, 9, 10 pages long. We're not expecting the client to be able to read through every line and understand every line of that durable power of attorney, but we need to make sure that they understand conceptually what is they're signing. Do they trust the person that they are able to name to make financial decisions and deal with doctors and deal with the government and do maybe the different planning tools that we might need to do to protect their income or assets to get them eligible for government benefits to help pay for care at home or facilities such as Medicaid planning, right? So whether or not they have the capacity to sign a durable power of attorney is not immediately eliminated. It's not immediately taken off the table just because they have a dementia diagnosis. It's going to be very case specific, very fact specific, very client specific. So if there's a dementia diagnosis, and we know we're not at the deeper end of the spectrum where we know they have, there will come a point in time where it will be obvious they don't have the ability to sign a new document. We certainly want to catch the client before they reach that high level of dementia or that advanced stage of Alzheimer's. Sadly, if that is the case, then sometimes we are forced into a guardianship position, but we really want to try to avoid guardianship if at all possible. And just because you have a dementia diagnosis doesn't mean you can't make decisions for yourself. It does not mean you can't sign a power of attorney. Hope you found this video helpful. If you have, please like it, please share it, please subscribe to the channel. We're trying to get good information to Floridians everywhere. I'm Jason Neufeld with Elder Needs Law. Thank you for watching.